want to thank all of our sponsors, which allowed us to put this event on today. What we're going to be discussing today during the hour of time that we have is the Art Van saga, from its inception all the way through the lessons that we've learned to date through each of the transactions that have occurred since the initial sale to Thomas H. Lee in 2017. My name is Ethan Dunn. I will be the moderator for today's panel. I am a partner with Maxwell Dunn in Southfield, where we specialize in restructuring and bankruptcy work with a specialization in Subchapter 5 small business restructuring. I also want to introduce you to our panel members, beginning with Laura Marcero.
Thanks, Ethan, and good afternoon, everyone. Again, thank you for joining our panel this afternoon. I am a managing director at Huron Consulting Group. I lead the practice from a restructuring and turnaround standpoint nationally. For Huron, we have a pretty substantial retail practice, both here locally as well as around the country, and have been involved in a variety of retail-related matters, both in the middle market as well as some of the larger bankruptcy-related cases that we're going to touch on here throughout that conversation this afternoon. But again, appreciate everybody joining and looking forward to a great discussion with my colleagues Ethan, Paul, and Brendan.
Paul?
I'll go next. I'm Paul Haig. I'm a partner at Jaffe Raitt Huber and Weiss in Detroit. I'm the chair of our bankruptcy practice. And my practice is mostly Chapter 11 bankruptcy work in Detroit, and as this case and many other cases in Delaware and elsewhere. So I'm a past president of the Michigan chapter of the Turnaround Management Association. I'm happy to be here.
Great. And Brendan.
Good afternoon, everyone. I'm Brendan Best. I'm the restructuring group leader at Varnum, based in Detroit. I mostly do bankruptcy and out-of-court workouts, represent companies as well as secured creditors. I also do a fair amount of unsecured creditor committee work in Chapter 11s. Lately have been doing a lot of retail bankruptcy work and out-of-court work and representing landlords, including a few landlords in the Art Van case. I'm also a past president of the Detroit chapter of the TMA, and I'm currently on the board of the TMA as well.
Great, thank you. And with that, we will begin our panel discussion. For all the attendees, if you have any questions, please submit them using the Q&A chat box at the bottom of your screen, and it'll allow us to save some time at the end so that we can answer any questions that come up. In the meantime, we will be monitoring the Q&A chat, so if there is a question that's relevant, we'll be monitoring it and hopefully we'll be able to answer it during the discussion. So Art Van, everyone in Michigan grew up with Art Van. Art Van was Michigan's furniture store. Anyone who grew up here recalls their going out of business sales. This company started in 1959. It was known for its unique way of marketing itself. It grew into one of the largest furniture stores that I'm aware of. And in fact, in 2009, won Furniture Retailer of the Year. And in March of 2017, after more than 50 years in business, there was a sale to Thomas H. Lee. So Laura, could you take us down the road and tell us about this T.H. Lee or the Thomas H. Lee transaction and the post-sale strategic moves?
Yep. Thanks, Ethan. That was a great setup. As we all know, Art Van, as Ethan highlighted, was an incredibly well-run, successful business for well over 50 years, and was a nameplate staple, right? Certainly here in the Michigan area. Not atypical for family-owned businesses that are considering, ways to monetize versus succession planning. The company did begin pursuing sale options in coming up to 2017, and look, they benefited from an incredibly frothy market that candidly is still here today, but from an M&A standpoint, the conditions were right. The company had been successful for a long period of time, and so had the right track record in terms of earnings and performance, and certainly the right brand name. So on paper, incredibly attractive and a great time in the M&A market to look at transacting. And in fact, that's what happened. Is the company was sold for over $600 million at an EBITDA multiple that was right around 7.5 times. So really very successful with a market premium on there. It was sold to THL, which has a ton of retail holdings and was very well known and respected at the time of the transaction in terms of what they had done in this space. So on paper, the transaction should have worked out really incredibly well, not only for the family that was able to monetize the business and do so at an attractive level, but also in terms of transitioning it over to THL, which I'm sure had plans to grow, scale it, drive efficiencies through it, and kind of take it to the next level. So again, should have been a transaction where everybody wins, and it's a successful outcome and a nice transition of a long-standing family business. As we know, that's not what happened, and the basis of the discussion here today. And so, really there's a couple of key factors, lots of factors, but a couple of key factors that I think really played into that. One of which were the sale-leaseback transactions that THL entered into at the same time as the sale was being consummated, that added lease expense and overhead expense to the company that hadn't previously existed. And so if you were to pro forma that back into what the implied EBITDA multiple would be, just that alone could have driven that multiple up to as high as 10 to 15 times. And so you say, well, gosh, if 7.5 was a large, an attractive multiple, you can draw your own conclusions about what that pro forma EBITDA really means in terms of the marketplace and what the outcome, could have been. And, certainly, Paul, I know you've been involved and been watching a lot of the large scale bankruptcies. So this probably isn't atypical from some of your experience. So
yeah, I'd like to comment on that if I can, because there is a frequently used playbook here in retail with private equity firms, and it has had some really disastrous consequences over the past decade. So PE firms frequently will acquire businesses and have been doing this in retail in particular through what is called a leverage buyout transaction. And as many of the attendees will know, a leverage buyout is when the funds that are used to acquire the business are obtained with debt backed by the acquired company's assets. So in an LBO transaction, most of the money that is put in to acquire the business isn't coming from the acquirer, the PE firm. It's the money that's borrowed when they lean up the assets of the target. In many cases, the PE firm only puts in 2 to 3% of the purchase price itself. So it doesn't have a ton of skin in the game. It doesn't have a ton of risk. The result of an LBO transaction, though, is you take a company that may have previously had a very healthy balance sheet, limited amount of debt, and you pile on millions and millions of dollars of debt because that's the money that's used for the purchase price to buy out the old ownership. And that leaves a very highly leveraged company that has a limited margin for error. And that's, it can work, but when you have, you partner that with what we all know is going on in the retail space, the move to online shopping and Amazon and more competition in particular markets, that limited margin for error becomes a real problem. The statistics say that 1/3 of all retailers who were acquired by private equity companies since 2002 have filed for bankruptcy. And that includes big names that we see at every mall we go to: Neiman Marcus and J. Crew, Guitar Center, Toys R Us, Sports Authority, Sur La Table, Payless, and of course, Art Van. a bankruptcy filing, if it doesn't work out, as I said, it's not good for the PE company. They do lose their investment, but the investment is relatively small. And while the PE company is operating the business, they have been paying themselves management fees and dividends. They've cut costs to be able to make those types of dividends. And generally, if it doesn't work out, their losses aren't so bad. So who gets burned? Well, it's the vendors, it's landlords, it's employees, and it's the communities, like in the case of Art Van, Michigan, that ends up getting burned by these types of transactions. I would suggest that the track record for LBOs by private equity companies in the retail space is not a good one. And so it's something to be cautious of as we move forward and there's more acquisitions.
So Laura, you just heard what Paul mentioned about the PE transaction from an LBO perspective. I'm wondering, what role or how big of a role did your traditional financing play in the Art Van operations?
Well, I think not only did you have, right, a frothy transaction that took place, you've got the dynamics in terms of an LBO, but you also had turnover of key management and senior level management within a short period of time at the business that proved to be, problematic in terms of a loss of institutional knowledge and relationships, certainly.
Like all of the management, right? Like 8 of the debtors, 9 top executives left of Art Van's left in 2017 and 2018. It's tremendous turnover here.
Yep. No, couldn't agree more, Paul. So right, you've got an LBO, you've got a turnover of management, and then you've got a PE that looks to add on other acquisitions and grow very quickly, right? And so when you look at the combination of the totality of those transactions that they tried to put together in a short period of time, it's nearly $1 billion, right? So not only are you trying to put all of those together, but you've now loaded additional cost onto an entity that hasn't been there before, and all of that probably was underwritten with some, what's proven to be some overly optimistic assumptions in terms of what that combined NewCo would look like, and certainly, what the PE could do in terms of growing the business and the profitability of the business. So look, I think that it was to a certain extent, problematic, as Paul mentioned, in retail, but it's also, I think, a victim of some of the frothy market conditions, not only from a transaction standpoint, but even coming around to the point you just asked about the financing, right? The financing market is incredibly competitive, even still now, and it was back in 2017 as well. And so you have lenders that are highly aggressive in terms of trying to be selected for that financing, and that generally leads to, in those type of market conditions, looser structures, looser covenants. And so that from time to time, may play into, some of the distress situations. Not always, but certainly is a contributing factor. When you have an ABL lender in particular, and in this case, there was an ABL along with a term lender there. Look, ABLs, as we all know, are underwritten based on the collateral that exists. So in this case, furniture, right? And so, there's an appraisal done on the furniture, and that underpins what the lender is willing to put out in terms of credit to, in this case, Art Van. But at the end of the day, the basis of that exit, the worst case scenario and exit for that ABL lender, is if the business doesn't perform. And as we all know, this one faltered incredibly quickly and was filing bankruptcy within 2 years of the sale transaction occurring. And really, when you look at what led to that, it's an unsustainable cost structure, lack of performance under this new business model. And I would have to imagine that the ABL lender at the time looked at the circumstances, looked at the losses, looked at the negative EBITDA, and said, look, you either need to go down a sale process, or you need to have money injected. As we all know, there were efforts along both of those paths, but there was not an ability to transact on one of those, whether there should have been or should not have been, I think is a matter for everybody's individual perspectives. But at the end of the day, the lender obviously made a decision that there wasn't an acceptable course of action, to move down. And so, look, it took action to begin to realize on its collateral, which meant that it had made the decision that it could liquidate out the furniture and the inventory and get repaid on its loan. Right.
So Laura, in this particular case, we had a Wells ABL facility. I think that's what we're talking about here. And you're kind of having a discussion about what happened leading up to Wells calling their default, forcing the liquidation and bankruptcy. You're explaining that there is a question here, though, in terms of the sale and leaseback transaction that you mentioned earlier. Is there any insight into, from a strategic perspective, post-closing with TH Lee, as to why that sale leaseback transaction was necessary?
Well, look, I mean, I think THL came in with their own capital to complete the transaction and use the sale leaseback as an avenue to recoup those proceeds, right, and put the debt that Paul mentioned on the balance sheet of the company. And so that really, led to the term debt being placed on the company. And so to Paul's point, right, they were playing a little bit to a large extent with other folks' money.
Yeah, let's highlight what the balance sheet looked like at about the time before the bankruptcy filing. So you had the asset-based lender, Wells Fargo, was first, and they're owed $35 million with the lien on the furniture. The sale leaseback transaction, and of course, we glean what we can from what's sort of publicly available information. We don't have all the details, but it looks to me like the sale leaseback transaction was really the way that TH Lee financed the acquisition. Art Van had valuable real property, and it sold it to these real estate trusts, and used the proceeds to acquire. TH Lee used the proceeds to acquire the business. That's what we talk about when it's other people's money. They didn't put up their own. They sold the assets of the company. That's the LBO component of this. Additionally, there's another transaction that took place later in 2017. And what the thinking, I understand, I believe what THL was thinking is that we should grow, we should expand Art Van. So they acquired a furniture chain, two furniture chains that were based in Pennsylvania and Ohio, called Wolf and Levin, which, like Art Van, were sort of iconic local furniture brands. And TH Lee, or really Art Van, acquired post the TH Lee transaction, acquired those furniture chains itself. So they expanded the footprint greatly throughout the Midwest. But that was a $260 million acquisition by Art Van itself, and so that's where the term loan debt came in. As I said, Wells Fargo, the ABL lenders, first with a $35 million debt, but below that there's KKR's debt, which is $175 million at the petition date, and which was used which was incurred to purchase Levin and Wolf furniture. And the result of that and then you have all the trade debt on top of that. So you had a company that had a relatively healthy balance sheet prior to 2017, and after these two transactions in 2017, you don't own the real estate anymore. The other assets are leaned up, and you've got $200 million of secured debt before you even get to the trade.
So Paul, thanks for that. And Laura, I want to go back to this Wells ABL facility to kind of segue right over into the actual Art Van bankruptcy. What happened leading up to the Wells calling the default and forcing the liquidation in the bankruptcy?
Well, Ethan, that's what I was mentioning in terms of Wells taking, I would presume Wells took a look at the performance of the business, the losses, the negative EBITDA, and what I imagine would have happened is they had a conversation with the company that said, look, I need a business plan that returns the company to stability. There probably needed to be some cash kicked into the business. As I understand it, there was a limited appetite from the constituents, whether it's THL or some of the other lenders, to put money in. And so then the other alternative is, look, you go down a sale process, or you agree to go down a sale route, and you need to produce an actionable offer there. And while I think there was an alternative that was backed by the family, at the end of the day, it didn't come together. You know, again, folks probably have different opinions on why that was, but it didn't come together. And so I'd have to imagine that that Wells took a look at it and said, you know, I'm not seeing cash come in. I don't have a business plan that I can have confidence in. And I don't feel as though I have a sale that the company can consummate in the short term. And so given the lack of all of those, my next best option is to call the default and begin liquidating the inventory, which again, right, in normal circumstances, that should have probably paid them out plus some. But of course, the timing of all of that was early March, and then COVID hits. Right.
Yeah, those are, I mean, when you
So
represent.
I think too that that's also a very important factor here. And Paul, were you going to add something to that?
Well, yeah, I was just going to say that. I mean, you know, we can all appreciate when you represent a secured lender being in that position. Wells Fargo's looking at Art Van and the problems that it has in January and February of 2020. KKR, who's got the junior secured position, has declined to put any more money in. There is interest from a consortium, a group of, there's this group of this consortium is what they're referred to, that was out there that was interested in buying up the Art Van stores. It consisted of the Van Elslander family members, the heirs of Art Van, the founder, and some landlords were on board with it, and other vendors. There was this group of people that was interested in acquiring Art Van to try and save it from this fate. But Wells Fargo, I'm sure, looked at it as the asset-based lender and said it's going downhill. And we can pull the plug on this thing now, liquidate our furniture inventory, and get out in full. And so it's an example of the different dynamics that are at play, the different interests that are at play prior to a bankruptcy filing. It's not, everybody's interest is not necessarily to maximize value overall, you know, and that wasn't the case for Wells Fargo. And so I think that in large part is what drove the bankruptcy filing was, you know, a lack of liquidity for the debtor, and Wells Fargo declaring a default, entering a forbearance agreement, which really steered this towards going out of business sales and looking, because they believed they could get paid from GOB sales fairly quickly and get out whole.
I think that's
I think that's actually a great place for us to kind of move forward and actually have a conversation about the actual Art Van filing and how that filing went. So
yeah, sure. So, you know, it was not a well-kept secret. I think a lot of people in our business in the month or so leading up to the Art Van filing had heard that it may well be coming because of the, you know, there was this default that was declared by Wells Fargo, and a forbearance agreement had been entered into, and it was headed towards GOB sales. There was rumors about the consortium coming in, but that eventually fell apart, and it was sort of your classic crash landing into bankruptcy. Art Van files a Chapter 11 case, several Chapter 11 cases in the bankruptcy court for the District of Delaware on March 8th of 2020. And the plan there was they had gone back, much like they had been talking with the Van Elslander family about coming back in perhaps and acquiring the Art Van business that fell apart. They had also gone back to the Wolf and Levin, the Levin family, and gone back to the former owners to see if they had interest in buying back their family business. And in that case, they did. And so they filed the bankruptcy case to effectuate a private sale of the Levin and Wolf brands. And it was going to be a quick private sale, do it in 2 weeks, the type of things that, you know, the bankruptcy law that we learned as law students that's not the way, it's not supposed to be that quickly, but this was an emergency, a melting ice cube, as they said. And so they were going to try and sell Levin and Wolf brands within the first 2 weeks of the case. And then the plan for Art Van, and what we know here in Michigan, was to run GOB sales and to complete those GOB sales and then liquidate the entire business by the end of May. Also a very quick process. A lot of the discussion on Art Van says that, well, then COVID killed it, but that's not really the case. Actually, the Art Van bankruptcy case was in big trouble even before COVID hit, at least, before it became part of our lives on a daily basis here. They had these first day hearings in Delaware on March 10th and 12th that were just disastrous. There were $35 million in customer deposits. People who would put down a deposit for their couch, they never got the couch, and they were unallocated for. There wasn't that much, that cash had gone into the business, and the judge was very concerned about that. The U.S. trustee was objecting to the debtor's attorney's retention in the case because the law firm that was hired to represent the debtors had also had a prior representation of Wells Fargo, so you got a conflict issue there about whether or not the debtor's attorneys can even be retained. And then the big issue was just on the eve of the bankruptcy filing. Again, they had a forbearance agreement with Wells Fargo, and the plan was really to sort of steer this towards GOB sales. And so a group that was a joint venture between Hilco and Gordon Brothers was going to get retained to run the GOB sales. But as part of the negotiations for retaining them, Hilco and GOB and Gordon Brothers, an affiliate of those liquidators, purchased the term loan debt, the $175 million term loan debt that was held by KKR. These liquidators purchased it, and that created all kinds of issues. The U.S. Trustee's Office in Delaware objected to the retention of the liquidators, noting, and it's just sort of just dropped in a footnote in the GOB motion, but you're trying to hire them as sort of quasi-professionals in the bankruptcy case, but at the same time, they're the secured creditors. They're the junior secured creditors behind Wells Fargo. They may be out of the money, but they're secured creditors, and so there's conflict issues that were raised there. And Judge Sanchi, who's a very, very experienced Chapter 11 judge, very experienced bankruptcy judge in Delaware, who has presided over more Chapter 11 cases than just about anybody, expressed real concern about this relationship with the liquidators, and he scheduled an evidentiary hearing. So they had already started the GOB sales. They come in to just say, we just want to continue it and hire our liquidators. And the judge says, I can't do this. We're going to have an evidentiary hearing. Come on back. And there was concern about whether they could even continue to do those GOB sales pending that evidentiary hearing. And then at the first day hearings, the other thing that happened is the landlords stood up and said, this is a flawed process here. The debtors, they pursued one buyer, the consortium. It fell apart. We don't think the business was properly marketed. We think there might be buyers out there. And the landlords didn't have a lot to show to support that argument until this unknown party, and Brendan's going to talk about this later, but somebody stood up from U.S. Assets, which ends up being Love's Furniture, stood up, and their counsel stood up at the hearing and said that they had approached the debtors about acquiring stores pre-petition, but had largely been ignored. So this is all in the first and second week of March. The case is off to a really bad start, and then COVID reaches the Midwest. Of course, people stopped leaving their homes. State governors closed many of the stores, and that was kind of the end of the liquidation, the orderly liquidation process in Chapter 11 that really never got off the ground. By March 19th, the debtor announced that it was pausing all in-store GOB sales as a safety measure. If you remember the newspapers, you had people lined up out of stores trying to get their couches, their tables out. They wanted their deposits back. Just a disaster. By March 20th, the Levin Wolf transaction, the quick sale of the Pennsylvania and Ohio stores, fell apart. And shortly thereafter, all employees were laid off. Benefits were not provided. There's been class action litigation about that. There was a Warren Act lawsuit. And Wells Fargo declares a default under the cash collateral order and tries to grab the cash, which of course, hard to do in bankruptcy. You got a problem there. The solution that the debtors had was that they took a play that was utilized in some other retail cases on the East Coast, which was to mothball the bankruptcy cases. And what they wanted to do is effectively hit the pause buttons. They were going to mothball the cases for 60 days. We're going to minimize the administrative burn. We're not going to pay rent during those 60 days. We're going to stay all litigation activity. People who have motions that they want to bring to court, we're just going to stay that. Of course, there's significant due process concerns with that type of a proposal. And the mothball request was not, I would say, very well received by Judge Sanchi, who noted that, creditors and landlords and employees, they have creditors as well. And so, you're here in bankruptcy, you got to fulfill your obligations. By this point, as they're burning through cash in Chapter 11, and as well as we know how to spend money in legal and professional fees here in Detroit, they really know how to do it on the East Coast. They've burned through cash at a tremendous, tremendous cash burn. And there's down to only $11 million left in the estate. Wells Fargo, again, is owed 35 to 40. So now Wells Fargo's out of the money. The GOB liquidation sales have never gotten off the ground. There's a complete airball for KKR, the liquidator's position. And the hearings got pretty ugly. There was a lot of finger pointing back and forth about who was to blame about this. This was the very first time we were doing hearings virtually. And so this was being done via Zoom. And, Wells Fargo was pointing at the debtors and blaming them. The debtors were pointing back at Wells Fargo. We got $3 million owed to employees. And the rent alone was $4.5 to $5 million a month, and they had no money to pay. So what they did is everybody agreed that there's no hope for this Chapter 11 case. They agreed to convert the case to Chapter 7 in early April. And I was serving on the creditors committee in the case representing a client. I represented a handful of different parties in the bankruptcy case. And so we had hired Pacholsky Stang, very well-known, very experienced business bankruptcy firm to represent us on the creditors committee. And when the case converted to Chapter 7, the Chapter 7 trustee hired Pacholsky to take over the litigation. And ultimately, the court did sort of mothball the case until June 1st. Everything was sort of stayed. The stores were closed. And until June 1st, it was everybody just sort of hit pause. To his credit, to their credit, the newly appointed trustee and the professionals were working very, very hard to try and make the best of a bad situation. And so they followed up their efforts and went back to people who had been expressed an interest in acquiring different assets of the business to see if they're still interested. So in early May, Store Capital, who was a landlord that had 27 stores, filed a motion to compel rejection of their leases. And in that motion, Store Capital said that they had a new tenant who was really willing to take over their 27 stores. And that new tenant ends up being Love's, which Brendan will talk about in a minute. Love's is starting to they're already in touch with key vendors to see if they'll provide credit. Love's is going to come in and try and take over these 27 stores. And ultimately, the trustee got approval from the bankruptcy judge of a sale process, of a sale motion, to sell effectively the inventory at those Store Capital stores to Love's. And that brought in $7 million into the estate, plus the assumption of some liabilities. In late May, the trustee went back to the Levin Wolf transaction and got that done. 32 stores in Pennsylvania and Ohio ended up getting sold by the trustee. And that also included, in addition to some purchase price, a fairly small amount, it involved the assumption of $25 million of liabilities of the estate. And then a very creative thing is, with all the furniture you have in these stores, there was talk about how we're going to get the stores open again and start GOB sales. They didn't have any employees anymore. Everybody had been laid off. It's just the trustee. So how do you run a GOB sale? How do you get that inventory out when you don't have any employees and everything's shut down? And so what the trustee did is he entered into a consignment arrangement with a company called American Signature out of Ohio, who sells furniture under the flag of Value City. And Value City took the inventory. They actually did open up some of the Art Van stores to run GOB sales. In other cases, they took the inventory that Art Van had, put it into Value City stores and sold it with a sharing of the proceeds between American Signature and the trustee. And so, one transaction after another, the trustees bring value back into the estate, trying to make the best. In this case, which appeared to be hopelessly administratively insolvent at one point, after one transaction after another, things start to look a little bit better. Throughout this whole process, the Van Elslander family is still out there, and they've expressed interest in different assets at the time. Early in the case, they'd submitted a letter of intent to purchase the debtor's intellectual property, the names, which of course was their name, the customer list and trade names and the domain, the website. Ultimately, the trustee moved to get approval of a bid to sell to the Van Elslander family for $2.1 million, the IP of the business, which is a significant offer for the IP. Value City, and what you saw happening as you got later in 2020 is there's this vacuum, there's this empty space in the Michigan market in particular for furniture. And not only was perhaps the Van Elslanders looking to get back into the furniture business, but Value City was looking to expand. And so they submitted a competing bid for the IP. And there was an auction there. And through that auction process, the Van Elslanders' $2.1 million bid for the IP gets bid all the way up to $6 million. And so again, it's a really, the sale process that was conducted by the trustee proves to be surprisingly successful. They bring money in. The trustee now has enough money in the bankruptcy estate that he buys Wells Fargo's position, just buys them out. And for a 70 cent on the dollar, discount, but bought Wells Fargo's position. So we don't have a secured lender to worry about anymore. And now the trustee can go forward to try and liquidate the remaining assets, which it did, and then make payments to creditors. And at the sale, at the hearing in the bankruptcy case where the court approved the trustee's proposal to purchase Wells Fargo's position, the trustee's attorneys said that we expect, when all of this liquidation process is done, that we'll have enough money to pay 100 cents on the dollar to both Chapter 11 and Chapter 7 administrative expense claims, and some money for priority unsecured claims. So that did not seem remotely feasible 6 months earlier, and I think you have to tip your cap to a job well done by the trustee. Our Van case is still going. I think preference actions are going to be pursued in the coming months. There may be other litigation that gets pursued related to the LBO transaction. Sometimes those things can be challenged as fraudulent transfers. I'm sure there's other claims and things that will be pursued, but that case is still ongoing, and it's still an ugly result. There's not going to be much for general unsecured creditors, if anything, but at least the administrative expenses of the case should be paid. And in the meantime, of course, Loves is just getting off the ground for its own dumpster fire, which I'll turn it back to you.
Right. So thank you, Paul, for that overview. And we are actually going to go to that. Brendan, one of the Chapter 7 asset sales that Paul mentioned was the sale to Love's Furniture, and that led to its own bankruptcy. So it's one we're all familiar with, and we'd like to have you tell us a little bit more about what happened with Love's Furniture.
Sure, absolutely. I thought that was a fantastic summary of the Art Van, truly a saga, not only pre-petition, but in the bankruptcy case in the Chapter 11 and the Chapter 7. So that was fascinating. And I mean, that's a great overview of so many different issues that happened. So as Paul mentioned, in the middle in the beginning of the Chapter 7 phase of that, there was a sale on May 4th. It involved $6.7 million of inventory being purchased from the estate, of inventory located at 27 locations. And then the landlord's store capital and essential properties waiving about $5.5 million of post-petition rent claims. So a $13 million pickup to the Chapter 7 trustee. And it was a consortium or a deal between Jeff Love, and those two landlords who were looking to fill space in vacant spaces. And Jeff Love was looking to fill a void in the marketplace, or wanted to attempt to do that. And so they purchased the assets they needed, and they were off and running to restart a number of Art Van locations. Kind of through theme throughout this entire Love's furniture story was that it was a very thinly capitalized plan that they had. The plan was to sell inventory located at certain locations that weren't planned to reopen, use that money to then fund the reopening of the locations that they did plan to start very quickly, and then to sell a lot of furniture and use those profits to then continue to fund. So there was really no large amount of startup capital here. So it's a plan that really had to work perfectly and have all the stars align and everything to go right. And quite the opposite happened. The stars didn't align, and the company within 3 months found itself completely out of cash. There's a couple of reasons for that. The big reasons, number one, is that in unlike a lot of 363 sale transactions that we've all been a part of, this wasn't a situation where an operator bought another operation, opportunistically in a bankruptcy. This was a company that didn't exist, called itself Love's Furniture, and then had to build an entire company, an entire structure of a company that had to work, it had to be functional, it had to be profitable. And they were supposed to do all of that within 3 months and then open up this multi-store chain, furniture chain, not an easy business to run. And so they had.
Can I comment on that real quick, Brendan? I mean,
Yep.
That's one of the things that you see as a theme with respect to both cases, is that the furniture industry, I understand, it really is a specialized industry. You got to know what you're doing. And so Art Van has all of its executives, all of the the people who know that business, who had been dedicated employees for a long time. They leave, and TH Lee replaces them with very bright people who, according to, you read the articles in the paper and you believe them, were flying in from the East Coast 4 days a week. They're very bright, but they don't know the business, and
Right.
That's a recipe for not succeeding. And what you hear about Love's is sort of the same type of a story. They didn't have the experience. Yeah, there's a market opportunity to sell furniture in Detroit, but do you know the business, and can you execute on that? And I think the same problem we saw replay just months later here with Love's.
Yeah, this may be an industry, especially a regional industry, that's difficult for a national, PE type of a player to come in and just plug and play and run this kind of business. And I think you're right. I think the same things that happened between 2017 and 2020 played out in like a microcosm in the ramp up of Love's Furniture. Another thing that didn't go right in a plan that had to go right was that the expenses during the ramp up exceeded the budget. And so while they were able to liquidate the planned inventory in the non-opening stores, and sales actually were pretty good when they started, unfortunately, their projections didn't provide enough cushion. And so this very tightly, capitalized plan busted in effect because the expenses exceeded the budget. So that was another main reason for them running out of cash in spectacular fashion. The other large problem they ran into was it's hard to operate a furniture business, was the inventory management and fulfillment process. They couldn't figure it out. They tried to figure it out on the fly. They ultimately moved their furniture to the Warren large warehouse location and hired Penske Logistics to manage it. They couldn't fix it. They still continued to have problems. And then they created another problem with a claim arising from Penske Logistics, where they also claimed it was a secured claim based on a warehouseman's lien. So the perfect plan didn't turn out so perfectly. By early December, Love's had decided to fire its management and start liquidating half their locations. They signed a sale promotion consulting agreement with Planned Furniture Promotions in early December and started liquidating. However, by the end of December, they were completely out of cash. They couldn't Basically what they decided to do was, well, we'll kind of skinny down our plan. Instead of opening up all the stores we plan to open, we'll kind of do what we did in the beginning, but let's do it again. So let's close a bunch of stores, liquidate that inventory, and then use that cash to then operate a smaller subset of stores. But that plan didn't work out either. They couldn't get enough cash to do that. And so by the end of December, they literally couldn't make payroll. They couldn't pay any expenses. And the only source of funds out there was the liquidator, Planned Furniture Promotions. And the only possible way that Planned Furniture Promotions was going to put in a DIP loan to pay those expenses was in a bankruptcy. And so they hired bankruptcy counsel on New Year's Eve, and 6 days later on January 6th, they filed for bankruptcy. So a pretty spectacular beginning and end to that company, where you saw grand opening signs literally coming down and being replaced with going out of business signs the next day. And I saw that driving down Woodward at the Royal Oak store, and that was a first for me, and probably a first for everyone. Just real quickly to talk about.
Let me just comment on one other thing there. I mean,
sure.
The liquidity undercapitalized from the start for sure. Love's was, and so you get to a point where you can't pay your vendors, your trade creditors, and so they cut them off, understandably so, right? And so you can't have a furniture store if you don't have mattresses to sell, and the mattress companies cut them off, and so they were going from one place to another trying to get inventory to sell. Well, they had two problems. They couldn't get new inventory in because the vendors cut them off because they weren't getting paid. Understandable. And then the inventory they did have, they couldn't find it because they didn't know because they were in this fight with their logistics company. They didn't know where the kitchen table was. Is it in this warehouse or is it in this warehouse? And how can we get it there? It was just poorly executed on all levels.
Right. And there's so many factors, and that's a completely different factor, which was that just like customers were canceling orders, the vendors were canceling shipments to them. So it all kind of crumbled at the same time. Just real quickly, I guess the highlights of the bankruptcy case itself, pretty straightforward liquidation case. There was some skepticism in the beginning whether this was going to work in a case filed in Detroit. As Paul mentioned, usually you don't have lightning quick sales. They're not typically received very well by bankruptcy courts, and especially when you get into smaller courts like Detroit versus Delaware, judges may be even more skittish about approving a situation where they already have this sale consulting agreement in place, the liquidation's already going. The Unsecured Creditors Committee stepped up and raised what you would expect them to raise as the typical types of objections. They took discovery, some very expedited discovery, but after discussions with the debtor, the committee agreed to consent to the plan, ultimately just basically saying that of all the different alternatives, this is really the best alternative to maximize the value. So the liquidation was approved under a cash collateral and going out of business sale order, which provides for escrowing of amounts from the liquidation into various buckets, seed money for a Chapter 11 plan trust, escrow money to determine pending determination of different claim disputes. And so the liquidation's ongoing. As far as I know, it's still continuing, although it's at its sort of tail end. And at this point, most of the inventory being sold is actually augmented inventory being brought in by the liquidating company versus the existing estate inventory, which is a typical thing you see in retail liquidations to bring people into the store to sell the harder to sell inventory. But nationally right now you have skyrocketing sales of furniture. And so they've sort of caught a wave there at the end to make this liquidation better than might have otherwise been. But just given the time, I'll leave it at that with the Love's Furniture. There's still a lot to happen in that case. You'll be hearing more about it, but I think that's good for now.
Or did you want to add something?
Yeah, thanks, Ethan. I was just going to follow on Brendan's point that some of the challenges that that hampered Wells's assumptions in terms of what they could liquidate the inventory out for, we're now seeing the flip side of that now because there's such a shortage of available inventory on whether it's furniture or otherwise that you can get in a short period of time. And so that's driven the prices up. So in this case, the liquidation has actually produced results that were above expectations, where on the front end with Wells Fargo, they came in well below, right? So different size, different results from a liquidation standpoint, both related to COVID.
So it sounds like we had
somebody's going to come in and fill this void on the furniture. It seems to me it's people. It may be traditional type of brick and mortar retailers, or it might be online retailers. But for decades, there are families who bought every piece of furniture in their house from Art Van. There's an opening there, I think, still. But the lesson from what we saw with T.H. Lee and with Loves is, it's not easy to execute on that. You need to know what you're doing.
Right. So it sounds like when we really look at this saga, we have a highly leveraged transaction that's where this all started. Then we have what seems to be a really risky financial model, especially considering some of the post-closing strategies that were implemented. But then we have this operational inefficiency that happens after your top operators exit the business that they helped to grow into what it was. And so the combination of those three really kind of exacerbated the decline here. What I'd like to know from each of you, though, is what takeaways do you have from both the Art Van and Love's case, and what are you still watching in those cases? Can we start with you, Laura?
Yeah, what I'm particularly curious in, Ethan, is just how this all plays out, right? So whether you have, some type of fraudulent transfer action that comes against the original transaction, right? Does that move forward or not? And likewise, really the investigation that I would have to imagine is going to take place here in some way, shape, or form as it relates to how the Loves purchase was put together, the undercapitalized nature of that, and really the ins and outs of where that money went. So those are the two things that I'm keeping my eyes open for, and curious as to how those play out and ultimately what the outcome is.
Thanks.
Yeah, I'll go next, Ethan. To me, the takeaway from this is the problem when you try and run a business and it's not adequately capitalized. And I can't help but look at the Art Van thing and look back at the LBO transaction and look at the really poor success rate of those transactions with many other iconic retailers in this country, and think that this is a strategy that we should be thinking twice about, because lots of jobs are being lost as a result of this. And so the takeaway for me is continued skepticism about that strategy, that playbook of acquiring a company with its own assets as really paying the purchase price. The other sort of takeaway or maybe looking forward thing that I wanted to comment on quickly as we were talking about these cases, where is I headed? I mean, they're both liquidations at this point. In Art Van, I know some preference demand letters have started to go out, and everybody who's involved in bankruptcy cases know those unpleasant things called preferences are always out there. You got to deal with them. But I want to comment on it in Love's Furniture. I don't know if, a trustee at the end of the Love's liquidation, if there will be a trustee or a plan, a liquidation trustee under a plan, or a Chapter 7, trustee appointed. But I'd like to suggest that whoever the fiduciary is in charge of winding down this business, think about the preference litigation in Love's, because this is not a normal Chapter 11 case. With most preference actions, trade vendors have two primary defenses: the subsequent new value defense and the ordinary course of business defense. And to the extent that payments during the 90 days before the bankruptcy filing were ordinary, they're protected by the ordinary course of business defense. But from the date Love's was conceived, there was no ordinary course of business. Love's was created in the middle of a pandemic. And vendors took a chance to support this struggling startup to try and make the best of a bad situation. And they all got burned. And I am concerned that with the preferences, they may get burned again. And so I would suggest that it's worth thinking about if that's really sort of the, this is the right case for all that litigation, although it would be very good for legal work in town.
Oh, Brendan.
Yeah, I'll just, I agree with that, Paul, and I would hate to be the committee counsel or the fiduciary who has to undertake that analysis, which is now required in the code to look at the viability of different defenses before you bring preference actions. And the ordinary course of business case law, when it comes to one-off transactions like you're talking about, yeah, it may suggest to you that the ordinary course of business defense would be available here. And it would certainly be difficult to say it's not going to be available. So the new bankruptcy code amendments about doing that analysis before bringing them is kind of an interesting thing. Two quick takeaways for me is, one takeaway is that, like as Paul said before, filing bankruptcy in Delaware is very expensive. And I think that was a big driver of Love's to sort of choose and maybe have to file in Detroit. And I think the good news is that the case went well when it filed in Detroit. And so hopefully that'll be a good example to restructuring professionals out there who, the talk now is that I'll never file a case outside of Delaware or New York or Houston. Hopefully we have shown that, Detroit can do a Chapter 11 case and not come to really illogical results. So I thought that was great. And then the other thing, a takeaway from Love's is, and I've been involved in 363 sales like this before, where purchasers are really excited to get the assets and it feels really good to do the deal, but not enough thoughts given to how to actually incorporate those assets into your business and effectuate. And a lot of money can be lost when that's not done right. And this, I can't imagine a worse example of that than Love's Furniture.
Great. Thank you, Brendan. And actually, thank you all of the panelists. We are open for questions. It is almost 5 o'clock though. We will have a networking session following this. And I don't see any questions in the Q&A chat. So at this point, I just want to thank each of our panelists for their participation. And I will turn it back over to Amanda.
Thank you all for your insight. Super interesting. As Ethan mentioned, we are going to have a networking session following this. I just posted the link in the chat, so you can just click that and it'll take you right over to the networking session, and the room will be open momentarily. And with that, I thank everyone for attending. We have some more upcoming events in May. All of those will be on our website. If you are not on our mailing list, you can send me an email at detroit@turnaround.org. Have a good night.